Preaching politics, that's what more than 1,000 pastors plan to do next month to fight for their freedom of speech.
The opponent, the Internal Revenue Service, pictured screen right, and its controversial tax code that prohibits tax-exempt organizations like churches and pastors from engaging in political discussions. So is that unconstitutional, or is the IRS silencing our pastors' freedom of speech?
Here with some legal insight, Fox News senior judicial analyst Andrew Napolitano. Judge, does this concern you?
Well, it does concern me. It's an age-old problem, Brian. The basic principle of law is if you want this tax exemption, meaning the people that contribute money to you do not have to pay taxes on the contribution, and the money that your group, whether it's the Archdiocese of New York or a very small independent freestanding church, receives, is not subject to taxation. Are you willing to sacrifice freedom of speech in return for that privilege? And the freedom of speech, the limitations on it are pretty precise. Full-time clergy employed by a full-time legitimate church that receives this exemption cannot, in an official capacity, advocate for or against specific legislation or for or against specific candidates. So Cardinal Dolan could have a conversation saying, I think you should vote for so-and-so for president. But he can't say it from the pulpit.
Well, that's interesting because it's happening all the time, isn't it?
Well, it is happening all the time. As Brian noted in the introduction, and as we were talking in the break, there are 1,000 pastors in the United States of America who in 2 weeks on a Sunday are going to challenge this. Question, will the IRS come after them? Well, the last time this happened, very famously, was not more than a few blocks from here, St. Patrick's Cathedral. John Cardinal O'Connor in 1984, Ronald Reagan and George H.W. Bush against Walter Mondale and Geraldine Ferraro, the late, great Geraldine Ferraro, who we all knew, a practicing Roman Catholic who favored abortion. Cardinal O'Connor said, no Roman Catholic can vote for Mondale Ferraro, and he said it from the pulpit. Did the IRS come after him? Of course not.
Of course not. Right now, as you know, the Catholic Church is mounting probably a good way to describe it would be an educational campaign where they're constant. Every week or two, they're talking about the contraceptive mandate where Catholic organizations have got to provide birth control, which flies in the face of what the Catholic Church stands for. So rather than saying, you know, maybe you should vote for the other guy because this is Barack Obama's policy, they're just saying, we're against this. You've got to connect the dots.
That's very interesting. This is already the law. So the tax-exempt speech prohibition does not interfere with your ability to criticize the law. Right. It interferes with your ability to advocate for legislation. So you didn't hear anything from Cardinal Dolan. I'll continue to use him as an example. When this legislation was making its way through Congress, you only hear his outrage once it's the law. That's perfectly lawful for him to blast this from the pulpit.
I bet a lot of preachers don't even know about this IRS law. It's very interesting. I love this topic. Here's some other questionable activity. Media Matters, in coordination with the Department of Justice, we've talked about that. They're a tax-exempt organization, and whether or not they should be allowed to continue in that status, right, Judge? Because they're not being bipartisan. Media
Matters has the exact same tax exemption as all the religious groups do, and so theoretically the same prohibition. What do they get away with? They collaborate with the Department of Justice to attack people like the four of us and our colleagues here.
There you go. All right, Judge.
He says that with a chuckle.
Well, because we're in good company.
Of course.
We are indeed. Boom!
I like how you always end it with a chuckle. It makes my day go a
And a
lot better.
slug. All right. Thank you very much, sir.
Have a good one, guys.
Welcome back, everybody. Back in 2010, the American Civil Liberties Union petitioned Washington under the Freedom of Information Act, which allows you to get documents. These, though, were classified, and they were about a drone program that our government rarely admits even exists. Judge Andrew Napolitano, Fox News senior judicial analyst, joining me now. Judge, you have to balance, of course, the right to look at government documents and our own national security. So what do you think about what the ACLU is trying to do?
Well, I would take issue with the word balance, and I would argue that there should be a bias in favor of transparency and in favor of people knowing what the government's doing. And every conceivable presumption or benefit of the doubt or argument should be in favor of the people knowing what their government is doing. Only if the government can show that our safety and our freedom will be harmed if it reveals what it's doing should secrecy trump transparency. So I agree with the ACLU. Look, we have gone from a program, we're talking about the president on his own sending drones to kill people, in several cases Americans overseas. We've gone from the government denying this program existed to the president acknowledging that he and some of his advisors and occasionally his campaign manager sit down in the White House and decide who the target's going to be, and they believe that somehow, from some source other than the Constitution, he has the power to do this. In my view, it's profoundly unlawful, and it is unconstitutional, and the more we know about it, the more voters can make an informed judgment as to whether they want a president who kills people and claims he can get away with it.
The ACLU is asking for a specific ruling on legal justification for a program like this. Is there any legal justification? Historically,
in my view, there is not. If the president wants to kill people in a foreign country, whether they're from the government or not, because he believes that they are about to pose an imminent harm to us, the only lawful basis on which he can do so, he has to ask for a Congress's permission to do that. But I'll tell you what the government will do. The government will say this involves national security secrets, and we can't even tell you what the justification is, even though the program is out there and the president has acknowledged it, and some of the people who have attended these kill sessions where they decide who to kill have talked to the press about it.
Do you think some release of information is better than none?
Yes, I do. I do. You know, Americans have the right to know what their government is doing in their name, to their Constitution, and with their resources. The more we know, the better we can decide whether we want to keep the government or change it.
I'm torn on this one, but we'll report. We'll let folks decide, because our safety and security, especially in these troubling times, seems paramount. Tough call.
I say our freedom is paramount, but Jamie, we'll talk about this all you like.
You're paramount, John. Thanks for weighing in today. It's an interesting case.
It
definitely.
is interesting.
$250 million. No, this isn't another stimulus. That is how much money may have been lost by NFL fans who bet on the Green Bay Packers to beat the Seattle Seahawks on Monday Night Football. But here is the catch. The Packers, well, they actually did win. But because replacement referees incorrectly ruled the final play of the game a Seahawks touchdown instead of a Packers interception, well, Seattle was awarded the victory. The NFL is sticking with that ruling. But could fans stick it to the NFL by trading in the gridiron for a gavel? Let's ask the judge. You know, this is just
a gavel.
But this is just one of many weird calls in so many weird games whose outcome was flipped by some bad calls.
Yeah, and the one last night, which honestly I didn't see until I heard Kilmeade exploding about it this morning.
Oh, he's always upset. He's very upset.
And then I listened to his explanation, and then I watched this tape a number of times. That may be the last straw. Stated differently, some people may actually try some class action litigation against the NFL. My advice to them is, don't do it. There's a rule that will fine lawyers for frivolous litigation, and in some states there's a rule that fines litigants for frivolous litigation. The NFL is a privately held corporation. The owners of that corporation are the owners of all the teams. They can put on any kind of demonstration or show that they want. The fans have no cause of action against the owners or their privately held entity, the NFL, because they didn't like what they saw.
All right, but what about where there's smoke, there's fire argument? There have been at least a half dozen such questionable games with questionable calls that affected the outcome. The Ravens field goal was real good. Replay showed the ball going directly over the upright, ruling upheld. There was another one, the Cowboy receivers slips, the touchdown. Is ruled ineligible because it was at his feet, it slipped. Ref was trying to indicate that a player had stepped out of bounds, comment, blah, 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 et cetera, reversed. In other words, one weird thing after another. I mean, if you're a fan, you could come back and say, as a fan, I don't even enjoy watching this.
I don't think this will happen because football fans, I know them because I have them in my family. I was once a very devout Giant fan. I like to see them win, but I don't go there as many games as I used to.
That could explain a lot.
We'll watch the game no matter what. But if they want to send a message to the NFL, don't go to the game. Don't watch the game. The pocketbook will send a message to the owners, and the owners
but what
will
if the
then
same numbers still
Roger
come?
Goodell
The owners don't care.
Well, the owners
We know we've got these bargain basement referees, and they're botching it.
Well, the owners might not care about empty seats aside from the appearance because they've already sold the tickets. But they will care if the ratings go down and their advertising revenue is reduced because they're not going to generate, not going to put as many eyeballs on the screen as they told the advertisers they would. You and I know how that works.
But in the end, the games go on.
Yes.
The likely bad calls go on.
Yes.
The questionable results go on.
Yes. So look, if this went on for years and years and years, someone like our mutual friend, the Donald, might start another league with real referees and get the better players to go there. I don't see that happening tomorrow. I don't see it happening next year. But at some point, people will say, we are fed up with this. This is not football anymore.
Wow. All right, Judge, thank you very, very
They
much.
should stay out of the courtroom.
Stay out of the courtroom. Me or the football?
It's going to cost them if they
Okay.
go in the courtroom.
We were discussing football. Was that it? Okay. Thank you, Judge.
So new concerns about voter ID laws in key states. Could new guidelines make for a long night on election night? Andrew Napolitano, the judge, is in the house. How you doing, our Fox News senior judicial analyst?
Right now, I'm hungry for bacon,
Yeah,
Bill.
me too. It's not even noon. What's going on here? What's the difference now because of these new laws? They say what?
Well, the laws in many states, and the Supreme Court has upheld this as being reasonable to assure that vote tabulations and election are accurate, require an ID issued by the government. So if a person shows up and they've always voted at this place, they've always lived at this address, but they don't have the ID, they can cast a provisional ballot. Now comes the problem. What do the election officials do with provisional ballots? Well, in some states, they will count the provisional ballots as soon as they can verify that this person is the person they claim to be, even though they didn't have an ID. In some states, they will not count the provisional ballots unless the race in that state is so close that the provisional ballots, if counted, could affect the outcome. Supreme Court has said these rules have to be uniform throughout the state. They can differ from state to state, but within a state, they have to be uniform. This is the first time that election officials have had this kind of burden imposed on them.
I got you. I'm starting to see it now. So there's a separate pile of votes that will be larger in the provisional ballot pile than we have seen before.
Yes, because people are likely to show up, and the election official would say, I know you're Bill Hemmer, and I know you live at such and such an address, and I know you've always registered here, but without the ID, I can only let you vote provisionally.
So we're going to cover our rear and let you do that. Now, what did the Supreme Court say in 2000, Bush v. Gore?
That whatever the state does, it has to do it uniformly. So they can't, for example, in one end of a state, quickly count the provisional ballots because they recognize the voter, but in another end of the state, take their time and verify who the voter was. They have to be the same throughout the entire state. If they do it in one part quickly and another part slowly, they're violating the rights of the voter in the part of the state where they did it slowly.
So get rid of the butterfly ballots, which has been done, by the way.
Right.
Now, listen, will this deter fraud? Will it get rid of folks who are not registered?
I think it will deter fraud. It will deter people from voting who are not registered. But it may cause all of us to work very early into the morning of the Wednesday after Election Day because it's going to slow down the final official tabulations. Remember, the process we're happening does not happen in one central location throughout any given state. It happens in hundreds, in some cases thousands of precincts. And they all have to do the same thing at the same time.
Or even beyond Wednesday if races are that close.
Oh, don't even say that, Bill. We've been through that in 2000.
Anyway, we like working. How many states are we talking about that could be impacted by these new laws?
A dozen.
12.
Yeah, some as large as Texas.
Right on, Judge. You'll watch it for us, won't you?
It's my job, Bill.
Okay, buddy. See you soon, all right? Bring the bacon next time.
You got it.
All right, later. Here's Martha.
Okay, we've been waiting to talk about this one. The data on your cell phone, the source of a new debate that's going before the federal appeals court.
It begins with a case, this is in front of the U.S. Court of Appeals in New Orleans, over whether police should be allowed to track you over your phone without a warrant for that information. But so much more is at stake regarding your personal information and your phone carriers. Nobody better to talk about this hot topic. Always hot, Judge Andrew Napolitano.
Wow. The topic or I?
Always you. I mean, you're in fuego all the time.
Look, this is my cell phone. I have it turned off. Right. It's off. However, it can still tell the police with a warrant, or if they want to break the law without a warrant, where it is. And it can also be used by the police with a warrant, or if they want to break the law without a warrant, to listen to conversations within earshot of the cell phone. The only way to disable it is to take the battery out. This case involves large-scale acquisition of information from telecoms about where cell phone users are at a given time. And a telecom that does business in Texas, but it's not named in the papers, basically said to the federal government, no, we're not going to give you this information without a search warrant.
Right.
The federal government, in its argument before the courts and against this telecom, has come up with some new theory of the Fourth Amendment that no one's ever heard of in 230 years. And that is, if some third party has your records, here the telecom has the records of where you are and to whom you're speaking, you don't have a privacy interest in them. Therefore, the feds can get it without a search warrant, and therefore the Fourth Amendment doesn't apply.
Now,
we'll see what the court says. This will be a radical change in the law if the court adopts the government's argument.
Far be it for me to read between the lines, but it doesn't sound like you think the government has much of an argument here.
No, I mean, the Fourth Amendment was written to protect fishing expeditions, really, to protect us from fishing expeditions. If the government believes that the possessor of a cell phone is engaged in criminal activity, it's pretty easy to get the search warrant, but there has to be that threshold. The Constitution calls it probable cause. Enough evidence so that a neutral person looking at this would say, yeah, this will probably lead to more evidence of criminal behavior. I'll give you the search warrant. But they just want your cell phones because they want them. They just want to know where you are because they're interested in you without any probable cause. That the Fourth Amendment was written to protect us against.
And you think that's the way it will go?
Yes, the trial judge in Texas told the feds, go get a search warrant. And by the way, I won't give you one because you haven't given me any reason for one. And the Justice Department is appealing it to the Fifth Circuit Court of Appeals in New Orleans. My prediction is that the Fifth Circuit will affirm what the trial judge did, and then the Justice Department will decide whether or not it wants to take this to the U.S. Supreme Court. It took a similar one to the court last year.
The government's just trying to fight crime. They're just trying to fight crime.
Their job is to
Don't get them going.
Their job is to preserve freedom, young lady, and you know it.
No, I think this explains a lot.
I only said that to him.
It explains a lot. You know, our stage manager.
So he would call me young lady.
Yeah,
That's really
our stage manager, Josh Patch.
One of the most unique characters of the Western world.
I just always thought it was funny. He takes his battery out of his phone when he's leaving the studio every day. Now, well, no.
You know how he knows that? In the old days, he was my stage manager.
Thank you, Judge.
Right there.
We're on to you.
What'd you say he's one of the most unique characters ever?
Let's go back to, speaking of unique,
bogged down, the fight over taxes just heating up. Europe is touting a carbon tax on airlines. Any and all with flights going in and out of Europe have to pony up a fee to help fight global warming. But that ain't flying well in our own U.S. Senate, just passing a bill to block the tax and insisting U.S. airlines don't have to comply. To the judge who says, easier said than done, Judge Napolitano, no fan of what Europe's doing, but you fly over there, you play by their rules. So, Judge, not all fair and fairs, I guess.
You know, you have put me in the awkward position of trying to defend a tax. I hate taxes. I believe taxation is theft.
Right.
But look, the countries have sovereignty. We ought to have known when we more or less supported and went along with the European Union, it would be a gaggle of socialists who would try and extract as much money from private industry as they could. Now they've come up with this new tax. But American airlines, I don't mean airlines that originate in the United States of America, will have no choice but to pay that tax in order to land there. I mean, the federal government of the United States of America could no more exempt airlines that are domestic to the U.S. from paying a European tax than the government of Great Britain or Germany could exempt British or Air or Lufthansa from paying a tax to the Port Authority when they land here. Wherever you are, the sovereign of that land has the authority to tax you.
Whether you find it fair or not. So foreign airlines that come here and have to pay this Homeland Security or security tax, that's the way we do business here. If you want to be here, that's what you got to do.
Correct. Look, we have...
So I just want it said that Judge Napolitano is in favor of a tax.
Negative. But I am in this awkward position of saying, under our present international law, the Europeans have the authority to tax an American commercial enterprise when it does business in Europe, whether the federal government of the United States wants it to do so or not. Whether the federal government believes it's a valid tax, they can extract the money from those airlines even if they don't use it to fight carbon emissions, even if they use it to give the money away. They can do what they want with it once it becomes part of their general domain. Even a dedicated tax doesn't have to go to the proposition for which it is dedicated. Once it's no longer in the taxpayer's hands, it belongs to the government. That's the law here, too.
I don't know, you're finding a very legalese way of saying you're in favor of taxes, but it might
How did I end up in this
I
situation?
don't know, but it is.
How did I let you do this to
It is
me?
a novelty. No, but very well put.
Top of the stack. After Wisconsin Governor Scott Walker enacted a law prohibiting collective bargaining for most public employees, a judge in Dane County, Wisconsin, now says it's unconstitutional. Joining me now is Fox News senior judicial analyst Andrew Napolitano. So, Judge, we've got all these constitutional arguments going on. Let's start with Wisconsin. So this Dane County judge says it's out. The people voted for Scott Walker. The legislature voted for this law. Of course the people's voice counts, doesn't it?
And he survived a recall and survived it overwhelmingly. And the essence of the recall was over collective bargaining. Look, the judge has found some constitutional obstacles in the Wisconsin Constitution. Whether he's motivated by a value set that generally supports unions, whether he's motivated by strict fidelity to the Constitution, I don't think we'll know. I do expect that this decision invalidating the Wisconsin law will be overturned by the Wisconsin Supreme Court. But there is an interesting kink here, and in the armor. One of the objections that the judge found was this doesn't apply to everybody. This does not apply. This does not invalidate collective bargaining for all public unions. It involves it for all public unions except police and fire.
Right.
Now, the Wisconsin Constitution and the federal Constitution have something called an Equal Protection Clause, which basically means you must treat similarly situated people or groups in a similar way. So how can you say to cops and fire, we'll recognize your right to bargain collectively, but to EMS and sanitation and teachers, we won't recognize your right? That's the conundrum that the Wisconsin Supreme Court will have to wrestle with, and that's the conundrum that this Dade County judge articulated in his opinion.
Let's bring it down the road. And the court and the Wisconsin Supreme Court, which is another whole part of this story, says, yeah, you got to have equal protection. Can't the legislature go right back in and say, fine, cops and firefighters, you too can't have collective bargaining?
Well, if they had the courage of their convictions, they would, and they could. But this was a rational and, as Bill Buckley might have said, elegantly wrought compromise. In other words, it was necessary to get some votes that the police and fire be exempted from this, because God forbid that certain legislators should want to treat the cops and the firemen the way they treat everybody else. There might be adverse political consequences.
Well, and they tried that in Ohio.
Yes.
And they did say everybody, cops, firefighters, every public employee, and the people went in and said, we don't like that.
In a stinging rebuke for our former colleague, now the governor of Ohio, John Kasich, it was invalidated.
Yeah.
Then, as you mentioned, Michigan, in which there's an effort to put on the legislature a constitutional amendment that'll prohibit a present or future governor or legislature from ever addressing this, because it'll become a constitutional right specifically articulated in the Michigan Constitution.
That's the question. Can you do that? Can you say from here on out no elected representative can change this constitutional amendment?
Yes, you can do that. That, of course, would require another constitutional amendment if, let's say, this thing in Michigan passes, and collective bargaining is a right enjoyed by all public employees in Michigan, articulated in the Constitution. That could not be interfered with by a court. It could not be interfered with by a future governor or legislature. It could only be done away with by a future amendment to the Constitution, meaning a referendum in November.
Forgive me, but I've seen these constitutional amendments that the people, the amateur lawmakers, have voted for in various states where they have propositions and initiatives, and later on a judge comes along and says the constitutional amendment is not constitutional.
That would be very, very difficult for a court to find. But I will tell you this. The U.S. Constitution, 22, 23 pages. Some state constitutions are over 400 pages because they are filled with very, very minute principles of law that political groups wanted to enshrine in the Constitution so that the legislature couldn't interfere with it. So don't be surprised if this thing passes in November in Michigan, only to be undone in November in Michigan 3 or 4 years from now when they realize how costly it is for labor unions to negotiate across the table with people they've elected to office.
And the latest polls are it's slightly a larger group in favor of saying, yeah, we want a constitutional amendment to allow anybody to collective bargain to join a union. But it's like 39%, 36% against it, but there's a 23% undecided, a huge undecided. So we don't know how this thing's going to turn out.
Right. We don't know how it's going to go out. Turn out. We do know that there is a crazy entity in Michigan, right outside Detroit, called Government Motors, which has financed the company, and which is the company's principal client.
Yeah.
The federal government and General Motors, of course, of which I speak.
Yeah, which is another whole story about GM. We'll get to that later.
Right, but we know how those employees are going to vote.
Well, let me go back to Wisconsin for a minute, because the Wisconsin Supreme Court, that was also, a lot of people outside of Wisconsin don't realize, that was another big part of the anti-Scott Walker movement. They were also had a vote for their Supreme Court justices. There was 2 judges, one who was pro-left, one that was pro-right. The pro-right guy won, which balanced, the tip of the balance for that court is to the right.
Now, the Supreme Court of Wisconsin has already ruled on this, but it ruled on the timing of the filing of the lawsuit in favor of Governor Walker and upholding the legislation. It didn't rule on the substance of the legislation, which it will probably be forced to rule on now. And very interesting, the Attorney General of Wisconsin says he wants to enforce the legislation while it's being appealed. That cannot be done. A declaration of unconstitutionality invalidates the legislation from the beginning. However, unless they're negotiating a contract, there's nothing to be enforced. This is not legislation that's enforced on a daily basis. It only comes into existence when a collectively bargained for contract expires and it's time to negotiate a new one.
And this isn't one of those rules or laws that, you know, gets debated and then just kind of drifts off. They've had demonstrable, measurable success in school districts and other government agencies around the state where they've saved money, increased the number of teachers that they've hired. It seems like people are pretty happy with it.
It seems like this was the right thing to do for the majority to do, that collective bargaining is not a natural right like speech or privacy or travel or religion. It's a privilege that the government can decide to give to certain groups and take away. And as long as the government does it fairly, the courts shouldn't be getting involved.
All right. We'll find out.
We shall.